I've been doing a lot of lawsuits over the last several years, and she's been involved in most of them, right? So and all those news outlets that call me, she's usually on the phone with them. She probably is like the third or fourth leading expert on redistricting in the country. So she's very qualified to be here as well. So this is a map of the first Congress. So this is back at the beginning of our republic. The map is Virginia, so it's Virginia plus West Virginia because it's back in the 1700s. And the little one with the black shows you where it is in the state. But this is the 5th congressional district in Virginia. And you may not have any reason to understand why that's important for our talk today, but I'll tell you why it's important. Do you know, Ken?
I do.
So this is James Madison's district. You know, the founding father who basically wrote the Constitution. And he decided he was going to run in the first Congress. If I get the story wrong, you can correct me. And Patrick Henry, who was the Speaker of the Virginia House, didn't want him to be in Congress. So he drew the district in a way to disadvantage James Madison and try to make it so his opponent would win. He was unsuccessful. James Madison won this district and was the congressperson here for several years before he became president. But he also actually ran against Monroe, who was also president eventually. And I think it's the only time that two people have ever head-to-head in a congressional race became president. Sorry for all the distraction. In the period before 1842, there was no requirement to have districts at all. The Constitution is, again, silent on this. And so for many of the elections, we just had at-large. So in 1842, you have the Apportionment Act that then required single-member districts. So this was the first time we required it. It's a federal statute. It's not in the Constitution, which means it can be changed. They did this. The kind of history of this is that the Whigs were in power, and they were electing most of the members were being elected in most parts of the country at large, and the Whigs were about to not be in power anymore. And so in order to prevent losing all of the districts, they instead said, we're going to mandate single-member districts so that they would hold on to a large number of districts that otherwise would lose. That requirement eventually went away, but in 1967, Congress passed a new statute requiring single-member districts. And so today we're governed under that. We have to have single-member districts for Congress unless the members of Congress decide to do something else, which they're able to do, but there's absolutely no appetite for that, and I'll get to that later. So now I'm going to kind of go through some legal doctrine without getting into the doctrine, because I want to go relatively fast to get to sort of modern day. But again, context is important. In 1946, you have this case, Callais versus Green. In this case, the U.S. Supreme Court said that malapportioned districts, so districts that have unequal sizes, is a political question, and it's outside of the jurisdiction of federal courts. And so they said it's not judiciable, so don't bring your claims to us. So basically, we had a free-for-all about how to do congressional districts at this point, because they said it's a political question and we're not going to be involved. This is 1946. This is going to come back to 2019. I'll get to that, but that's 1946. In 1962, you have a really important court case. In fact, it's taught at all the law schools, I found out, in constitutional law classes as the political doctrines question. And Baker versus Carr overturned Cosgrove. Okay, it said, actually, these questions are not beyond the scope of federal courts. And this is not that long, all right? So 1946 to 1962 is not a long period. I should have started, I was a little distracted by saying that most of what I'm going to say today is a little depressing, but there are some notes of optimism in there. And one of them is that courts change, right? And here, the court is going to change and say, actually, we can do something about this. And so in a 3-year period after Baker versus Carr, they heard a whole number of cases, and they completely reversed course. And they said, actually, it's not just judiciable. We're going to do something about it. And they determined that all districts for Congress, for state legislature, and everything down, right? Anywhere we re-elect, the districts have to be essentially equal in population, right? So this is important, right? Because in the Callais case, the evidence in that case was plaintiffs in Illinois where they hadn't done redistricting since the year 1901. So for 40 years, they did not do redistricting, even though the state of Illinois was growing immensely, and particularly Chicago. The Chicago area was growing immensely. And so some districts had as few of about 140,000 people, and some districts had about 1 million people in them. and they each got the same vote, right? So it was completely unequal. Baker versus Carr, Westbury versus Sanders, Reynolds versus Sims said, no, that's not it. In Reynolds versus Sims, if you ever get a chance to read one court case in your life, I think it should be Reynolds. As people who believe in democracy and are, here on a beautiful night to listen to me, right? You should read Reynolds versus Sims. It's got some really beautiful language about how it's people who vote, not trees and acres. And just wonderful language about what it is to be a democracy and why our democracy is important and the importance of our vote and making sure people can have an equally represented vote. So it's a really important court case. Again, completely overturning this whole long history of manipulation. But there are shortcomings in this doctrine. And that is that in doing equal population, they basically said, we care that you have an equal vote, but not that your vote matters equally, right? That was never in there, right? Just that you get the same amount of vote. But of course, what you probably already know is that you can draw districts to manipulate and to make it so that a person's vote, even if it's nominally equal, that it's not actually equal. And so just a few years later, Congress sort of says, okay, we got to do something about that. And they said, we're going to pass the Voting Rights Act. So the Voting Rights Act in 1965 is clearly an important part of this story. Maybe it's the whole story. Because this is going to be the first time where Congress actually tries to say something about what the districts ought to look like, not just that we have districts. And there are going to be, several provisions, lots of provisions in the Voting Rights Act, but two that are particularly relevant for redistricting, for drawing districts. That's Section 2 and Section 5. Section 2 says that you're going to have a ban on any electoral practice that discriminates on the basis of race. And Section 5 says for states that have a history of discrimination, that you can't change any law unless you get it cleared with the federal government first. So basically, this is directed at southern states, right, with their history of slavery and then Jim Crow. So there was a formula, and the formula was based on whether you had a history of discrimination. It's mostly the southern states, but it actually included lots of northern counties where there was discriminatory practices. So like, for instance, in Long Island, New York, we're subject to some of these provisions, and in California and everywhere. But the states that were mostly concentrated in the South. Okay, come back to both of those provisions. But let's start with Section 2. Section 2 is kind of the most important one because it covered the entire nation. And it didn't matter if you had a history of discrimination or not, you still were subject to Section 2. And it prohibited any action that disenfranchised minorities. But that was tested pretty quickly. And in the courts, in this case, Mobile versus Bolden, a group of black voters sued in the city of Mobile, Alabama, and there were citywide elections that were held at large. Right? The idea again, like all of West Virginia is going to elect. All of the city of Mobile is going to elect at large. And the idea there was if you did that, white voters could outvote black voters, and they could have 100% of the representation, no matter what the population of the black voters was, as long as they were under 50%. And because of what we call racially polarized voting patterns, where black voters tend to choose candidates that are different than white voters, right? It had that effect of basically discriminating against blacks. So they went and they sued, and the Supreme Court said in Mobile versus Bolden, well, actually, Section 2 of the Voting Rights Act only prohibits intentional racial discrimination, which means that like the city of Mobile didn't say we're doing this to discriminate against blacks. It just had that effect, right? And they said, well, that's not enough, and so they refused to side with the black voters in Mobile, and Congress said, well, that's not actually what we mean, right? That's not what we meant. We meant that it is prohibiting any action that discriminates on the basis of race, including those that are indirectly doing it. Right, so these things. So this idea that it's an effects test, not just an intent test. You don't have to prove intent. You just have to show that it has the effect of discriminating against blacks. Well, under that test, certainly an at-large election in Mobile, where whites always get their candidates elected and blacks never do, is discriminatory on effects. And so the Congress, in a bipartisan way, with Republican President Ronald Reagan, who signed the bill, signed this, and that was the new law. So again, the moral of that story is that the courts did something bad. Congress came in and said, well, we don't like what you did, and we're going to change it, and we're going to go to something we like better. So again, that's uplifting, right? No matter where we are today, where we are tomorrow is what's important, right? Okay, so 1986. We're moving chronologically. I have a time up here. You can see I have a lot more to get to. So I should go a little faster. But so that's Voting Rights Act, right? So Voting Rights Act and Mobile versus Bolden is Voting Rights Act. Then you have this case in 1986, Davis versus Bandemer. I'm sure nobody's ever heard of this case. So Bandemer versus Davis is an Indiana case, and it comes to the Supreme Court, and the question is whether partisan gerrymandering is a violation of the U.S. Constitution. So racial discrimination is clearly a violation of the 15th Amendment. Well, how about partisan gerrymandering? Is that a violation of the Equal Protection Clause of the 14th Amendment? Well, the court says in a plurality vote, maybe. So there were 4 justices that said it's justiciable, that you can bring claims in federal courts about partisan gerrymandering. But we don't know yet how to deal with those questions. And so they basically said, they upheld Indiana's plan, that it did not violate the Constitution, but they said it's potentially out there. So 1986, potentially out there. Same year, one of the most important cases in U.S. history. Now, you probably have heard of this one. My guess is you may have heard of this one. No? Okay, this is the one that was just overturned in April. Right, so that's kind of like why I was asked to come and talk. Right, so this is 1986, Thornburg versus Shingles. So Thornburg versus Shingles says it's the same thing as Mobile versus Bolden, but under the new VRA, the one that says that it's an effects-based test. So it goes to the Supreme Court, and they can now invalidate that. Right? But they don't. They say, yes, Congress had the right under the 15th Amendment, because there's like multiple sections of it, and one of them is that Congress can make a law to enforce the 15th Amendment, and that's the VRA. And so Congress has the right to say that it's also an effects-based test. And in this court case, Thornburg versus Shingles, it was a North Carolina case about voting rights and about whether it discriminated against black voters. Black voters brought the case, and the court agreed with them. And they put a 3-part test. So there's 3 prongs to the Jingles test. Well, I have it written here so I can get it right. 1, the minority group must be sufficiently large and geographically compact to form a majority of a reasonably configured single-member district. So they have to be a large group. Like, you can't just say, like, there's 2 black voters. It has to be like half of a district. So a lot. And 2, that the minority group has to be politically cohesive, right? So that they all have to choose the same candidates, or a large percentage of them choose the same candidate. And 3, that the white majority has to vote sufficiently as a bloc to usually defeat the minority. Right? Does that make sense? So it's a 3-part test. It's actually a pretty hard thing to clear. Right, because you have to have all these components. The hardest thing to clear is the numeracy, like to have enough people. Right, that's not easy to do in many places. So like Asians are a protected minority group, but Asians are not concentrated in any districts in a large enough percentage to usually get covered under these provisions. And black people may or may not be. They are usually in the South, but not usually in other places, just because there's not enough. And then Hispanics increasingly over time were opted into this because they were growing so large in numbers. But the point is that the court ruled this and said, yes, this is our law. Congress is allowed to make these laws, and we have a mechanism to enforce it. And for 40 years, this is going to be the law of the land, right? So I'm going to skip ahead to 1993, right? So it turns out that 1992 is a really important year because now you have Section 2 of the Voting Rights Act that has real teeth, and it's going to be enforced rigorously, and state legislatures are going to actually take notice of the new Voting Rights Act, and they're going to draw those districts. I'm going to show you how that later in the presentation. I'll show you how the Voting Rights Act worked. like why it worked and how it worked. Okay, oh, it's so sad the colors look kind of weak here. The colors are CMU colors. You just can't really see them. I like to brand everything. This is actually a really famous district. This is like the I-85 district in North Carolina. And this was drawn as a black majority district. And so after Thornburg versus Jingles, state legislatures started to draw these black majority districts. But there's still partisanship, after all, taking place here. And here, what they're trying to do is to maximize the number of minority districts. And so instead of drawing a compact district around the black population in North Carolina, and I'm going to walk over to my map. I know I'm going to lose you. I'm loud enough so that you can hear me. But this district is going to span from all the way down here, all the way through the state, okay? That's a long district. They call it the I-85 district because at points in this district, the district is only as wide as the freeway. Like if you open both car doors, you're going to be in 2 different districts or 3 different districts, right, depending on where you're at. Right, so the court in Shaw versus Reno says, actually, you can't do this. This is not what we're asking you to do in the Voting Rights Act. In fact, there's no reason to have done this. They did this in order to maximize the number of black districts, and actually it was probably to maximize the number of Democratic districts. So Democrats controlled legislatures in the South in the 1980s and 1990s, and they wanted to keep the white Democrats in place, but also increase the number of black Democrats. And the court said, no, you can't do that. So they struck down these districts, which then basically has the effect of reducing the number of white Democrats. And so the states didn't like that. Southern states didn't like that at the time. But it turns out that in 1994, things are actually changing in the South anyways. I really wanted to have this as part of the slide because this is a really important point, I think, in American history. Maybe an underrated point. I sometimes have said to people that this is like the end of the Civil War. Like it ended in 1994, right? Because basically you have the Civil War and it becomes completely like Democratic for a century or a century and a half, right? Democrats win everything, right? Because they're so mad at the Republicans, the radical Republicans, for passing the 13th, 14th, and 15th Amendment. They never vote for another Republican again until 1994. In 1994, the South starts voting for Republicans. It actually dates earlier than that. You have Nixon's Southern strategy, where they start to make racial appeals and try to persuade white conservatives to join the Republican Party. But it kind of ends in it has the effect of taking root in 1994. It's the first time in 40-some years that the Republicans controlled a majority in the House of Representatives, and they're going to start winning state legislatures at this point as well. And that's going to be really important for partisan gerrymandering and racial gerrymandering from that point on. So 1995, you get another case that's basically in the same line of doctrine as Shaw versus Reno, which is what is called racial gerrymandering. So it's using race in inappropriate ways, as opposed to the Voting Rights Act, which is using race in appropriate ways. Here, they're packing black voters into a district, but it's not as crazy looking as the Shaw versus Reno district. And the Supreme Court, in this case, says, well, it's not just the shape that matters. It's really what's going on inside the districts. So they strike this district down as a racial gerrymander. And so state legislatures are going to start taking control. Republicans are going to start taking control of the southern states after the 2000 election, because now you've completed the revolution, right? The South is now Republican in 2004. But there's another court case that kind of pops up, Veith versus Jubileer in 2004. And it's, again, one of those cases like Bannemer versus Davis that you probably never heard of, because in some ways it's unimportant. It is a U.S. Supreme Court case. But here, so you have a long period between Bannemer versus Davis and Veith versus Jubileer. And in that long period of time, no district court ever struck down the plan as a partisan gerrymander. And so the Pennsylvania Republicans controlled the legislature, and they drew this plan that favored Republicans in Pennsylvania, and Democrats brought lawsuit and said this is a partisan gerrymander, and we've got data to show that this is a partisan gerrymander. And the court has a plurality opinion. They don't have a majority, so there's no binding precedent here. And they say, actually, Bannerman versus Davis is wrong. It's not a judicial question. Right? You can't bring claims of partisan gerrymandering. It's not a judicial. Federal courts are not going to be involved, but it's only a plurality, right? So it's not binding. That's why it's like not an important case in some ways, because it didn't like definitively rule anything out. But some of my mentors wrote a book about why this case is actually the more important case than anything that came after, because like the 4 justices that were in the plurality ended up getting their way. They got what they wanted in the end. That's like the depressing part of the story. There's a lot of depressing parts. Okay, 2006. We're moving through the timeline pretty swiftly now. 2006. So court case here is in 2 parts. One, it's a partisan gerrymandering case, and also is a vote dilution case. It's a Section 2 case. Why is it important? It may not have actually been that important for any talk about redistricting until last year. And the reason why it's important is because it happened in 2003. Remember I told you that Republicans are going to start taking control of state legislatures? Well, Democrats controlled Texas at the beginning of the decade in 2000. And they drew a map that benefited Democrats. Right? I know it's hard to believe Texas, it's hard to believe, but yeah, I mean, it's a southern state, right? Texas is a southern state. It was a slave state. And Democrats controlled it. And they drew a map that discriminated against Republicans. But in 2002, Republicans took control of the state legislature. And you guys remember Tom DeLay, the Speaker of the House, and he's from Texas? Well, he orchestrated a mid-decade redistricting in 2003. And that's why this is now important, right? And so this case, well, again, 2 parts. One was a Section 2 case, and they actually did rule that the district that I'm showing here was drawn in a way to diminish the electoral ability of Hispanics that were growing quickly in that part of the state. So they struck down that district. But on the question about mid-decade redistricting, they said, actually, no, that is constitutional. And so that's the first time they ever ruled about mid-decade redistricting. And so that's why we can do it today. It's because here they said you could do it. And, the kind of like the facts of this case, I actually reread them yesterday. It's kind of interesting, right? The Democrats did draw a partisan gerrymander, and the Republicans took control of the legislature, and they redrew the map. And like the court says, like, I don't know how you want us to strike down this map when the Democrats drew this other map just before that did the same thing, right? And they said, so we can't really rule on that. Again, they didn't say that you couldn't do it ever. They just said you couldn't do it in this case. Anyway, so you can do mid-decade redistricting. That's 2006. Now we're going to go to 2012. And the Great Gerrymander of 2000. My friend Sam Wong from Princeton wrote an op-ed for the New York Times called The Great Gerrymander of 2012. So I stole that headline from him. That kind of took off a lot. You'll actually see that in a lot of places and books written about this thing. Basically what happens after the 2010 census, Republicans had a strategy. It's called the Red Map strategy. They spent a lot of money winning state legislative elections in 2010. It was a bad year for Democrats. Remember, Obama won in 2008. Midterm elections are generally not good for the sitting president. So 2010 was not a good year for the Democrats. And the Republicans got wise, and they said, we can spend not a lot of money on state legislative races because they're relatively cheap. And when we do that, we'll control redistricting for the next decade, and we'll draw gerrymanders. And they did that. And so the district you're seeing here is the Pennsylvania 7th District. It's called Goofy Kicking Donald Duck. Right? That's what they called it, because if you look at it, it's like, it looks like Goofy Kicking Donald Duck. I always say, right, if I'm giving testimony to a court and I can get the judge to give the district a name, I've won. I've won. Right? You don't want the judge to give you a name. But so 2012, right? So you have Republicans controlling, a lot of districts. Do I have the numbers here? I think I do. Maybe I don't. I have them later. I have the numbers later about what number of districts they controlled drawing. They drew a lot, and it includes Pennsylvania. So this is Pennsylvania 7th. It's a suburb of Philadelphia. Suburbs is where elections are won and lost in America. You draw districts like that, you can manipulate the outcomes. And that's what they did. In Pennsylvania, there's 18 districts. The Democrats actually won a majority of the votes in 2012. They won 5 of the 18 districts after winning a majority of the votes. This happened not just in Pennsylvania. It happened all over. I got data here. North Carolina, Democrats won a majority in North Carolina. Republicans won 9 districts. Democrats won 4. Right? And there were brutal gerrymanders all over the country. Wisconsin, Michigan, all these purple swing states where the vote was about 50-50, where Republicans dominate the election. So 2012 was really bad in this way. 2013, we have Shelby County versus Holder. I'm not going to dwell on this one too much. You guys all know this one, I think. But the critical thing here is that it's going to get rid of pre-clearance. And that means that instead of the South having to go to the federal government to have their districts approved, they can draw whatever districts they want. Now, this is not going to really be important until 2020, and it turned out to not really matter that much, in my opinion. We can still not like it and think it's a bad opinion, but it didn't seem to have, like if I look at the data, it didn't seem to have the very negative effect that we were really thinking we were going to have. But we're going to have that anyways in 2030, not because of Shelby County versus Holder, but because of everything that came after it. Cooper versus Harris. You can see this. A lot of the redistricting court cases that go to the Supreme Court come out of North Carolina. North Carolina is the worst offender in the country, which might seem a little surprising. Well, it is to me, because it feels like it's kind of a swing state, and like Republicans don't really wield a lot of control over North Carolina. The governor's a Democrat right now. Democrats likely to win a U.S. Senate seat this year. But historically, it's just been ripe with these, Thurgood versus Jingles, Shaw versus Reno, Cooper versus Harris, Rucho versus Common Cause, which I'm coming to next, which is like the most important one for partisan gerrymandering. But here, this is like the high watermark. So this is like when the courts are actually enforcing things in a way where people like me feel pretty good about the doctrine, right? We don't like Shelby County versus Holder, but it has had no effect at this point because we haven't redrawn districts. Cooper's Harris says Republicans drew this map to disadvantage Democrats, is what they said, and they did it by packing black voters. So they discriminate against black voters, they discriminate against Democrats, and the court said, no, you can't do that. You cannot redistrict to discriminate against against black voters and then say that it's all partisanship. Like we're not going to allow that to happen, right? So you can't use it. They say you can't use it as a proxy. This is all going to be short-lived. They're going to completely overturn this. So it's like, this is the high watermark. There's also a case, I don't know why I didn't add it here, Bethune Hill out of Virginia. It's same year. It was actually like the second case I was ever involved in. I drew the map, remedial maps, in that U.S. Supreme Court case. It was the same thing. They said, race cannot predominate in the drawing of districts. You cannot draw in order to discriminate against black voters, and it cannot be your motivation in drawing the map. In Virginia, they drew all of the districts to be 55% black without using any data. They just said every district has to be at least 55% black. They got all the black members to go along with it, right? The black members of the state legislatures loved it. They're like, oh, this is great. The vast majority of my constituents will be black, which means I am going to win every time. But like it really hurt Democrats because you packed all the Democrats into just a few districts. 15 in that case, 15 out of 100 in Virginia. And of course, no, you can't predominate like that. You can't set thresholds. If you're going to use race, it has to be in order to comply with the Voting Rights Act. And that's the only reason you can use race. Again, they're going to overturn that too. So like in some ways, it's all kind of irrelevant. We're in 2017. I was already active at this point, right? And everything that we did in 2017 is overturned now. Another case you never heard of because it kind of went nowhere, Gill versus Whitford. Again, West Virginia had one of the worst gerrymanders in 2010. Plaintiffs, Democrats came and said, we are going to say that there is a statewide challenge. We have a measure, the efficiency gap that was developed by political scientists. and lawyers, and we're going to demonstrate that the map it's a 50-50 state and it's completely biased against Democrats. And the court said, well, actually, you can't bring a case statewide. You can only bring district by district cases. And so back to the drawing board, right? So Democrats say, okay, we'll come back, we'll bring a new case. Simultaneous to that, there's another case out of North Carolina. Surprise, surprise. Rucho versus Common Cause. Rucho versus Common Cause is the same kind of idea, right? Statewide, Democrats are getting about 50% of the vote. Republicans get about 50% of the vote. But when you look at the political makeup of the congressional districts, the Democrats are getting wiped out. I don't remember what it was here. I think it was 13-3 or something like that. When the Republicans drew this map, they had to redraw this map after Cooper versus Harris, right? So this is the map that they replaced it with. And they said, well, the only reason we didn't draw a map with more Republican districts is we couldn't figure out how to do it. So they admitted that they did it with the intent to discriminate against Democrats. Well, this went to the Supreme Court, with really good evidence too. Like, it's pretty obvious, right, to anybody who has a logical brain that if you get 50% of the votes, you ought to get about 50% of the seats. And if you don't, that there's something wrong. But they brought all kinds of computer simulations. They drew millions of alternative maps, and they said in almost none of those alternative maps did Republicans win this many seats. It was an outlier. They went district by district. They did everything the court asked. Well, what does the court say? Actually, this is not a judicial question. Federal courts can't be involved in this. We don't know what is too much. Right, so what Bandemer said in 1986, gone. What the plurality of the justices said in Veith, that's the new law. So this is bad. Right now, that means that the federal courts are not going to be involved in policing partisan gerrymandering. So here's Chief Justice Roberts writing for the majority opinion. This is a quote. This court's one person, one vote cases recognize that each person is entitled to an equal say in the election of representatives. Right, so that's the Baker versus Carr. Everybody's entitled to an equal vote. It hardly follows from that principle that a person is entitled to have his political party achieve representation commensurate with his share of statewide support. Now, that might be obvious to Justice Roberts. That is not obvious to me, right? It feels like if I live in a democracy, my vote not only should have an equal weight to everybody else, that it should have an equal ability to elect my candidates. I should never be disadvantaged in my ability to elect candidates, right? Because I choose a political party or I choose to vote for a political party. That's not what Justice Roberts thinks, though, and not what the majority on this Supreme Court thinks. But, reformers and people who are active in this space said, well, that's not the end of the fight, right? That's just federal courts. In Rucho versus Common Cause, John Roberts goes out of his way to say that there are other ways to prevent partisan gerrymandering, right? We can go to state courts. You can have state laws that say you can't have partisan gerrymandering. States can go further than the federal Constitution. And so what happens is the venues shift. So now we're not allowed to sue in federal court on partisan gerrymandering. You can bring a claim, they're going to dismiss it before it even gets heard. But you can do it in state court. So goofy kicking Donald Duck, right, from 2012, that actually gets wiped out by the Pennsylvania Supreme Court. Because they say, the Pennsylvania Supreme Court, that it entitles every voter to a free and equal election. And that means that it's not just that you live in a district that has the same number of people as everybody else, but that your vote counts equally. And they weren't the only ones to do this. North Carolina did the same thing. They have a free and open clause in their constitution. And then they read it exactly the same way. They said, your voters are entitled to have an equal say in their government. And they overturned that map. And so both of those maps disappeared. Again, there's good news to be had here. Other states have other kinds of, so those are constitutional provisions. Other states have done things like put in independent commissions where they say, well, politicians are not going to draw the lines at all. We're going to let citizens draw the lines and take the incentive away from them. Places like Florida have state statutes that say partisan gerrymandering is illegal. So there are things that can be done. And the other thing that can be done is that Congress, through the elections clause, can change the rules and prevent partisan gerrymandering. We'll get back to that. So these are our new standards. Here's some data. This is from 2020. So what I wanted to show in this map is which party controlled who's going to draw the lines, who's going to draw the districts. And looking at this map, you can see that it's a lot of red, not a lot of blue, and then kind of a lot of gray. And so the colors are, gray means that no party is going to do it. It's either going to be an independent commission or they're going to have divided government. So Pennsylvania, after the 2020 election, elected a Democratic governor. And so it was a state legislature that was Republican, and the governor, Tom Wolf, was Democrat. And without his signature, they couldn't pass a gerrymander. Right? So that happened in Michigan and Wisconsin. So a lot of these places where there were partisan gerrymanders, but not everywhere. North Carolina is still red, Texas still red, and then Democratic states too. But here are the numbers. So Republicans had control of drawing 177 districts, and Democrats 49. So I mean that's pretty big difference. Independent commissions drew 110. And courts drew another 91 in the end. So the difference I promised you I had the data. I do have the data here. In 2010, Republicans drew 206, the Democrats 44. And I don't know why I didn't write the difference, but there is a difference there, right? So from 170 from I'm losing my 206 to 177. So a reduction in the number of districts where Republican can draw, a slight increase for Democrats. I think it was like 5 additional ones, and all the rest of them were drawn by courts or independent commissions. This is kind of another positive thing that happened. A lot of people have analyzed the maps after the 2020 census and said that it was near parity. So the great gerrymander of 2012 went to the great parity of 2020. Again, until last year.
I'm curious how independents play into this whole thing. I mean, because at some point, I'm guessing there's going to be a whole lot more independents than there aren't anybody in any one of the other parties.
Well, I mean, so the story of independence is complicated and maybe beyond my scope here. When it comes to independent commissions, right, they actually usually do get a say in some cases. Independent voters get a say in the drawing of the lines when they're independent commissions, right? Because it's citizens that are going to draw the maps, and so they get a seat at the table. If it's drawn by state legislatures, independents get no seat at the table because in almost no state are there independents who are elected to office. One of the big criticisms of gerrymandering is that it reduces competition, and where you have reduced competition, you get more people who are very partisan and less independents. So the story is basically independents don't have much say over it, but have more say when you take it out of the hands of the politicians. Does that make sense? Okay, so again, good news in 2020 is that we have a reduction in partisan gerrymandering in terms of the number of states, districts drawn by partisans, and an increase in the independent or court-drawn ones. By the way, just FYI or like fair warning or whatever you want to say. I drew the districts in New York here, so the court drew them. I drew them. That was my project. And if you read the newspaper about what happened there, they'll say that there were more competitive districts in New York than any state in the country. The map I drew, basically because I drew it without partisan interest, right? We drew them neutrally, and that had the effect of creating more swing districts, for lack of a better word. So here's a plot that shows you the number of districts from each cycle, 2012 on the left to 22 on the right, that were drawn by commissions. So 40% drawn by commissions or courts in 2020. Again, all good news. This is all good news. Then, this is kind of a good news case. So Moore versus Harper is a court case about the independent state legislature theory. Basically, a Republican sued in North Carolina, surprise, surprise, saying that actually courts and independent commissions cannot draw maps, that only state legislatures can draw maps, because the election clause gives broad discretion to state legislatures. But the court rejected this argument 6-3, which is not really that great of news, that 3 justices still think that like we can't have independent commissions. That basically means there are no rules at all. But still, that's kind of what happened in Moore v. Harper 2023. After Moore v. Harper in North Carolina again, this time in state court, right? So they have elections for judges in North Carolina and in many other places. I don't know what West Virginia does. Pennsylvania are partisan elections for our Supreme Court justices. A lot of places in the U.S. are, some are not. But in North Carolina they were. And Republicans were able to defeat a sitting Democrat or 2 sitting Democrats on the North Carolina Supreme Court. And then they immediately brought their congressional districts back to the Supreme Court of North Carolina. And the new court, the new Republican court, said, actually, our Constitution does not protect voters that way, and that the legislature can draw the map however they want. So they replaced in 2024, they replaced their neutral court-drawn map with a partisan gerrymander. So back to where we were in 2012. So the story's starting to get a little bit negative again. And that's by the way, I believe, by my count, our first mid-decade redraw was in 2024. So before Texas, before the whole kind of shenanigans has propped up. New York also redrew their map. So I told you I drew the map. Theirs was not as aggressive as what North Carolina did. So the Democrats in New York were quite upset at my map. They didn't like it. And so they forced one of their judges off the bench in New York and replaced it with a liberal so they could overturn my map. They kind of did. They basically said that the legislature and the commission, they have a commission in New York, gets a chance to draw the map. Not that there's anything wrong with my map. The court never ruled that my map was bad or anything. They just said that they get another chance at it. And they did. But in a surprise, you can look this up in the New York Times because they did a lot of coverage of this. It was like a big surprise. They actually kept most of my map exactly the way I drew it. They drew some differences in the margins, some changes that benefited Republicans actually, and some that benefit Democrats, but very much kept it very much the same. That's our second redraw of the decade, partisan redraw. Okay, back to section 2. I'm sorry, I know we have till 8:30 is what we scheduled. I don't really want to go till 8:30 because the kids are waiting at home, but I want to get through some of this stuff. This is I think the most interesting stuff maybe. Right, so Allen versus Milligan, section 2 of the Voting Rights Act. Thornburg versus Jingles, 40 years ago. Allen versus Milligan, this is 2023. Right, Alabama draws a new map after the 2020 census. A third of the state is black. A third of the state is black. They draw 1 out of 6 districts to be black, and the rest of them are white majority Republican districts. This goes to the Supreme Court. They said that's a violation of the Voting Rights Act under Jingles. Plaintiffs say we can prove all 3 prongs. We can show that the blacks are concentrated enough to draw a district where they constitute a majority, that blacks vote cohesively, and that whites usually vote against the interest of blacks. It's clear cut, right? The evidence is clear cut in Alabama. And it goes to the U.S. Supreme Court, and everybody thinks at this point that the Voting Rights Act is toast because the Supreme Court has been hostile to the Voting Rights Act since John Roberts has been on the court. I don't have this anywhere in this presentation, but I'll just say if you don't know this, Chief Justice John Roberts worked for the Department of Justice under Ronald Reagan, and his goal in the Justice Department was to undermine the Voting Rights Act. That was what he was tasked to do. Right, so everybody thought it's toast at this point. In a surprise, and we were all surprised, they upheld it. And if you read the language of it, it's like shocking. John Roberts writes the majority opinion, and he says, we've been doing this for 40 years. And nothing in our doctrine has changed, and we're not changing it today. And they struck down the map in Alabama, and they said, you must redraw it with 2 black majority districts, which also meant there was a simultaneous case in Louisiana going on where a third of their voters are black, and they drew 1 out of 6. I think it was similar. 1 out of 7 in Alabama, 1 out of 6 in Louisiana, something like that. I can't get the numbers straight. But basically, they said you got to draw a second black majority district in Louisiana too. And because of the Allen versus Milligan, they both had to draw this additional black district, which they both did and were both used in the 2024 election. So the sitting members of Congress today, there are 2 black Democrats from Alabama and 2 black Democrats from Louisiana today in Congress. Because the U.S. Supreme Court said we had to, because Congress said we had to in 1982. Right? And so this is where we were. This is where we were until April of this year. After that, right, came this case, Alexander versus South Carolina. I know there's a lot of doctrine. I don't really know how to do these talks without really getting into the weeds. One day I'll figure out how to just show some maps and make everybody happy. But like, this is the stuff that excites me, and I think it's all really important to understand the context. So Alexander versus South Carolina. Here it's a Charleston-based district, Nancy Mace's district, if you know Nancy Mace. Democrats sued in South Carolina and said that they drew that district. It was Charleston is it's interesting. It's beautiful. If you've never been there, it's a beautiful city. I love it. I went with Alex, actually, his daughter. We went down there. It's a beautiful city, and it's full of Democrats, or at least it has a lot of Democrats. Some of them are white and some of them are black. And so this court case was a little bit different than some of the other ones. They basically said, you're discriminating against black voters by having made Nancy Mace's district more Republican. And they purported to show that they disadvantaged black voters. In the end, the court said, well, you haven't really distinguished partisanship from race. And it appears as if South Carolina was just enacting a partisan gerrymander. And we already said that you can't bring a court case on that. And they couldn't separate out the white voters and the black voters sufficiently. And they said some other things too, that ended up in retrospect being really important, though not everybody picked up on it at the time. They said for plaintiffs to win a racial gerrymandering lawsuit, that the plaintiffs must bring an alternative map that shows that the legislature could have enacted all of their goals, including partisanship, and it would not have changed the racial circumstances. Turns out that that's now what is now the main law. That's what Louisiana versus Callais said. We didn't really know what they meant by that at the time. It's much worse than we even thought. Basically, it's an impossible standard to prove. Right? Basically, they would have had to draw a map in South Carolina that drew Nancy Mace's district to be a Republican district, no matter what. Right? And that's defeating the purpose. If black people in South Carolina are all choosing Democrats, right? The only way to draw these districts is to discriminate against the black voters. You can never win. And I'm going to show you today. So something came down today while I was finishing this presentation that forced me to add another slide. You probably don't even know about this one yet. Because I can never finish anything because there's always something new. All right, you know this guy? The animation is too slow. This is an animation. Why is the text not showing? All right, I'm going to take him off. He says, I have it, he's holding up, it says, I am entitled to 5 more districts, is what Donald Trump says. Okay, he says, I'm entitled to 5 more districts. This is last year in the summer. This is about Texas. He says, I'm entitled to 5 more districts because I won the state. And that makes, it's all kind of strange. You can hate Donald Trump, we can do whatever you want. But let's just think about these words for a second. I'm entitled.
Yeah, we heard it.
Entitled? Nobody's entitled to anything in democracy. You go win these districts. Right? You're not entitled to them. You don't redraw them so that you're guaranteed to win. That language itself is problematic, and I don't care who said it. Right? It doesn't matter whether it was Trump or somebody else. Nobody's entitled to anything in a democracy. That's the point. But anyway, so he said that. He said we're entitled to it. And so this kind of starts this craze that we've been living in for the last year. At least I've been living in for the last year. I can't go anywhere without redistricting being the headline. And so they do this new map, they start this new process. There's a lot of facts. I'm not going to get to all of them, but the Department of Justice sends a letter. So the Department of Justice is controlled by Donald Trump, his administration, right? Sends a letter to Texas saying 4 or 5 of your districts are unconstitutional because a court had ruled that you can't have coalition districts. Coalition meaning you can't have black plus Hispanic districts, like that make a majority under the Voting Rights Act, which is not at all what the law said, or what the court said. The court in Texas, there was a court in Galveston County who said that the Voting Rights Act cannot require you that you draw those districts. But not that those districts are unconstitutional or illegal, just that you can't require them. But even that wasn't like settled law. That was a district court, one district court, not a Supreme Court. But they sent this letter anyways. And then the Trump administration and the governor of Texas sort of start trumping this. We've got to redraw our districts because we've got illegal racial gerrymanders. And the governor goes and does all these press conferences about this. And then, in a sudden twist, they start saying, no, it's not actually about those coalition districts. It's all about partisanship. Because they realize you can't draw districts based on race. If they were to change the map and say they did it for race, that's unconstitutional, actually. So they start saying it's all partisanship. In the end, it was this big fight. Now, you've all definitely lived through this and experienced this. Democrats fled the state to deny a quorum. Eventually, they had to come back. They passed the map. Plaintiffs sued. I don't remember who. I think it was a coalition of minority voters, Hispanics and blacks, because there's a lot of all these populations. There's a lot of people in Texas. And they all sued and said, this map is illegal. It's a racial gerrymander. Our evidence is that they came and said, we got to redraw these maps for racial reasons. Pretty clear-cut, like racial. Actually, the district court, the three-judge panel, which is required by federal statute in these cases, heard this case, and they ruled in a 2-to-1 opinion, including a Trump-appointed judge, ruled that this was a racial gerrymander. And they struck it down. They said, no, you can't do that. And they used that evidence that the governor was out here saying this is all about race, it's all about race. And you can't run away from your statements. And they struck it down. 2 or 3 days later, the U.S. Supreme Court said, no, it's all about partisanship. And they restored the map. So this is our map. Because we don't have any rule of law anymore. I'll get to that at the end. All right, so California retaliates. You got Prop 50. So let me say one more thing about Texas. So you can't see it. They say that they got 5 more districts for Republicans. It's be hard to tell here. I've done some data analysis on this. I think it's closer to 2 to 3 additional districts. We'll find out in a couple of months. But I don't think they're going to pick up 5 districts. I think there's no chance that they're picking up 5 districts, especially in a bad Republican election in 2026. California retaliates. They put it to they had an independent commission draw their map. It's relatively fair, which means there's actually a lot of room to draw partisan gerrymandering. So the problem in Texas was they already drew a partisan gerrymander. So there's not a lot, like if you have a lemon and you've already squeezed it, there's not much left you can get out. If you cut a lemon fresh and you squeeze it, you're gonna get a lot of juice. Okay, that's my metaphor, right? There wasn't a lot of lemon juice left in that lemon in Texas. So they got like 2 or 3 more districts. California is really ripe because it was drawn by an independent commission. So they redrew their map as a retaliation to Texas, direct retaliation. They brought it to the voters, had the voters vote on it. The voters approved this new map with about 65% of the vote. Which roughly matches the partisanship of the state. And so California has a new map that's going to net Democrats 5 additional seats. I've done the data analysis on this. I think it's very clear they're going to pick up 5 seats in 2026, like without a doubt. And actually, the sly thing about what they've done in California is in the data, I see that it can potentially give the Democrats additional 9 seats. And the reason is because of all these swing state suites down here, they all became blue, like really blue. So in bad elections for Democrats, which 2028 or 2030 might be a bad election for Democrats, they're not going to lose those seats. So this map might be worth about 9 seats. I actually talked to the map maker a couple weeks ago. I had coffee with him. We were both in DC for something. And he agrees with me. He said, yeah, that's what we did, right? We drew it to shore up all those incumbents too. And they kind of had to do it in order to not create other kinds of problems in the map. The Republicans sued on this and said it was a racial gerrymander, but the court said no. So far, the U.S. Supreme Court said no, it's not a racial, it's a partisan gerrymander. So the court's at least kind of consistent with that, and they let them keep this map. All right, so Louisiana versus Callais. Where are we on time? I really got to get it going here. Okay, so Louisiana versus Callais. This is like what you asked me to come talk about. We're there. We're finally there. All right. So in Louisiana versus Callais, right? It's actually a really complicated lawsuit because it goes to the Supreme Court years ago, and they hear it, and then we waited to the end of the term. On the very last day of giving opinions last year, the court says, actually, we want to rehear the case. They didn't rule on it. So then they had another oral argument this year, and they heard the case again, and they asked, so originally it was a question about the Shaw versus Reno doctrine, which was racial gerrymandering. Originally, the case was brought, they said, this district that you see on your screen here, which is the second black district that was drawn in response to Allen versus Milligan and Robertson versus Aradon, I think it was. They drew the second black. They said, actually, the plaintiffs were white Republicans. I think they call themselves non-black voters, is what they call themselves in the lawsuit. Not my words. It's what they say, we're non-black voters. So white voters are suing as a racial gerrymander, which is kind of different, right? Usually racial gerrymander cases are going to be brought by minorities because they're the ones who are harmed. Now you have white voters coming and saying that it's a racial gerrymander because white voters are harmed by this map. Basically, they say, like, you can't draw a map that goes all the way across the state like that. That's ridiculous. And you might look at that too and say, that's like, if I didn't tell you anything about it, you just saw that district, you might say, that's kind of ridiculous. Right? You didn't have to draw that. But the kind of like knife in the stomach on this one is they didn't have to draw it like that. Louisiana drew it like this on purpose so that they could get it struck down later. They could have drawn a district, again, I'm just going to come and point at the screen. Like they could have drawn a black district that looked kind of like that. The geography is a little bit funky in Louisiana. It's a funky looking state. But you could have drawn a black majority district that kind of just was like that. They didn't have to do that. But that's what they did, probably because they wanted it struck down. Now, the state at the time said, we have Speaker of the House Mike Johnson. We don't want him to lose. We've got Majority Whip Steve Scalise, or Majority Assistant, whatever. He's some number 2. They also had number 3, powerful chairwoman of a committee, Letlow, who's going to be a senator now. And they said, we don't want them to lose their elections. So we drew it like this to comply with the court order, but not sacrifice those incumbents. Now, people like me who believe in minority voting rights say, that's fine. You drew the second black district. I don't care how else you draw the districts, as long as you don't discriminate against black voters. That's fine. And so this map, in my view, is fine. It wasn't the best map that could have been drawn, but a normal looking map would have taken out Letlow. And they didn't want to do that. Understandable. They still complied with the Voting Rights Act by doing this. But that's not how the U.S. Supreme Court finds it. So basically, they said, not only is this district not allowed, you actually don't need to draw this at all anyways. There is no reason to draw a second black district because the Voting Rights Act only, so let me kind of like make sure I get this all right here. The Voting Rights Act isn't just an effects-based test, no matter what Congress said. It's only intentional discrimination. So back to Mobile versus Bolden. So they overturned Thornburg versus Jingles. They don't say that in the court case. They actually go out of their way to say they're not doing that. They absolutely did that. They overturned Thornburg versus Jingles because it's now not an effects-based test. You have to prove intentional racial gerrymander, which they say this is, right? Because you drew it on the basis of race. And so now the state can go back and draw whatever map they want. The state actually could draw a map with 0 black districts. They're not going to end up doing that in the end. I'll show you the new map, but they probably will in 2030. So there's a lot of things going on. I do have a couple more slides on this. I'll read this to you. These are quotes. The first quote on the top is Rucho versus Common Cause. So this is the partisan gerrymandering case from 2019. The conclusion that partisan gerrymandering claims are not justiciable neither condones excessive partisan gerrymandering nor condemns complaints about districting to echo into a void. So in Rucho versus Common Cause, John Roberts says federal courts are not going to be involved in police and partisan gerrymandering, but we don't condone it, and nothing about it is constitutional. Like, as a social scientist, I say, okay, maybe. Like, yeah, it's hard to like say what is excessive and what's not, and we're gonna like back out of it. I think they're wrong. I think they should do it, but like, well, it's like okay, and, like this is okay. We don't condone. Okay, let's fast forward to like April. So this is again a quote. This is now Sam Alito. So Sam Alito wrote the opinion in Calais. Thus, in considering the constitutionality of a districting scheme, courts must treat partisan advantage like any other race-neutral aim, a constitutionally permissible criterion that states may rely on as desired. Did y'all hear that? It's a constitutionally permissible criterion to create a maximum partisan advantage, to discriminate against half of the country is constitutionally permissible, to dilute your vote is constitutionally permissible. They just said in 2019, that's 7 years ago, that it's not constitutional. They've overturned all of their own precedents. And they're like kind of sly about it. They say, well, we're not really doing that. You are doing that, right? And we're already going to see, like I'm going to have a few more slides here. We're almost done. As you can see, we're almost done. Although it was a really active year, so there's a lot of slides in 2026. But we're already going to see the effects of this. So they do a lot of things. They say, we're not overturning Thornburg versus Shingles, we're just updating it. But they're updating it by like taking it back to 1965. Or actually probably like before that, actually. It's not really, it's not the kind of update that I like whenever I like update my phone. I like it to get better, not worse. And they do this, by the way, this is, for me, the reason I have this on the slide is, this is the most disturbing part of the court opinion, is that now partisan gerrymandering is constantly permissible. So like, there are lots of ways, I draw districts, that's one of the things I do in my life. There's lots of ways to draw districts, right? And there's lots of ways to draw good districts, lots of ways to draw bad districts. We try to like opt towards things that are good. And traditionally the court has said in like racial gerrymandering and when they're policing these things, they say that you must draw like compact districts or those that are based on communities of interest or political subdivisions. But they've now elevated like partisan advantage to being the same as those. They don't seem the same. Like the first set of things were things to like constrain legislatures, to like rely on good government type things, and partisan advantage is doing the opposite thing. It's very disturbing. And well, I'll get there, but even today, like courts are already doing this. They're saying that this is the new law of the land. So Section 2 was not technically repealed, but I will be shocked if any plaintiff is successful at winning a Section 2 case until either the court changes or Congress passes a new law. And even that, I'm not sure they're able to do because they passed Section 2 of the Voting Rights Act in 1982, and it doesn't seem to matter. And we have the 15th Amendment, and it doesn't seem to matter, right? We still have Section 2, but if nobody can prove a case, then what's the point of having it? And I think in the dissent, Alana Kagan said it's all but dead letter, and she's right. Okay, so I promised you a slide of data of the effects of the Voting Rights Act. So I know you won't be able to see any of the text, and that's fine. I'll explain it to you. So what you're seeing is a bar chart. I'm colorblind, so I don't know what the colors are. The one on the left are number of black representatives. The one on the right is the number of Hispanic representatives. We start in 1961, and we end in 2025. And what you can see is that there are almost no black or Hispanic representatives in 1961, before the Voting Rights Act, almost zero. I think it's one, actually, or two. And it basically stays the same. And after the Voting Rights Act, right here, starts to climb. We start to get more. Voting Rights Act it's working, at least a little bit working. But it's not really that many. Right? And then you hit second line, 1982. That's after Mobile versus Bolden, when the Congress passes a new Voting Rights Act that says it's an effects-based test. And that's when you start to see lots of increases. In particular, you see an increase after 1992, which is when every state is required to redraw their districts. And now they're going to draw the districts to actually provide minorities an opportunity. So you see a sharp increase. And then you see it kind of plateauing, but that's mostly because it's been successful. And then some slight increases after even, so the reason why I said Shelby County maybe not so bad is you still get increases after Shelby County. It's not actually, Shelby County did not decrease the number of minority districts by itself. But the data is a little bit like screwy here because it's just like this is like a descriptive representation. Is the member of Congress Hispanic or Black? And a lot of these districts are coming from white majority districts in places like Pittsburgh, like where I vote. Summer Lee is my representative. She's a Black woman, but our district is a white majority district. And so that's part of the story that's happening here too, is that white voters are becoming more likely to vote for Black candidates in non-Black majority areas. But still, the overall picture here is a picture of success. The Voting Rights Act has worked. I'd say it's the most important piece of legislation ever passed in American history, and this is why. I can show you different kinds of data that are very similar in nature, but the Voting Rights Act worked. And the next question is, what's going to happen now that we kind of don't have a Voting Rights Act? Maybe we go back to here. Maybe we go back to here. Really quick, now we're really kind of getting to the time. This is a map of the mid-decade redistricting with the data that I put together. Basically, I took every election that I could get my hands on, and I projected it into each of the new districts in each of the old districts. So this is not just like the presidential election or the congressional election. This is like elections to governor, election to US Senate, placed into the districts. And then said, how often do each party win these districts, and how did it change when you change the maps? And so this is where I said, I don't think Texas is 5. I think it's 3.29 on average. And I don't think California is 5. I think it's 6.25 on average. And it ranges from 3 to 9 or from 2 to 5 on those two states. And the Florida gerrymander was supposed to give 4 additional districts. I have it at 2 with a range of 1 to 4. It will definitely give at least 1 more Republican seat. You see Louisiana and Alabama are both going to be +1. That's because they eliminate the Black majority districts in those 2 states. Anyways, that's my data there. We can come back to it. Louisiana, I'm done. So you can see this is the new map. You can kind of see the old outline. This is the new map. I don't know why this shape is that much better than this shape, right? Well, smaller, but like it's funky and it like crosses from New Orleans to Baton Rouge. The shapes are not better, right? It's still a gerrymander. It's just one that discriminates against Black voters. Alabama redraws their map. So this is actually kind of interesting. This is June 2nd, 2026. Actually, it was like the day before I was supposed to give the talk I based this talk on at Pitt. It was like, oh, okay, got to add a slide here. So they drew the 2nd Black district in Alabama to fulfill the Voting Rights Act. So Republicans said, no, we want to go back to our 1 Black district map. And so they did, they passed it, and Black plaintiffs sued and said, no, you can't do that. Like that, just because Louisiana was told they could go back to this doesn't mean Alabama can. It's a different case. District court ruled with the plaintiffs. They said, actually, this is intentional racial discrimination because you're eliminating a district that already existed, and you're basically saying it's because of race. And the district court wrote 150 pages. I read every single one of them. 150 pages outlining how the state intentionally discriminated and how that's still illegal under Louisiana versus Callais. 2 days later, what do you think the U.S. Supreme Court does? They overturned that district court. They said, no. You're misreading us again. They can go back to 1 Black district. So they're back to 1 Black district. The shocking thing about these 2, Louisiana and Alabama, is that they didn't eliminate both Black districts. Because you can. It's not hard. It's not hard to do. Right? You just crack the Black voters, put them into, there's 6 or 7 different districts. You put a third into each of those districts or a 6th into each of those districts or whatever. Very easy to do. You can create all Republican districts there. I'm going to skip this, right? It was just like, it's just happening so quickly here that everything is changing. Everything that we thought in 2017, 2018, 2019 is all changed, and not for the better. So here's one, and this is going to bring us to today, actually. So shortly after Callais, after the US Supreme Court struck down the Voting Rights Act, Tennessee says, okay, well, we're going to get in this action too. We want to create a 9-0 Republican map. We don't want any Democrats, right? The legislature is a supermajority Republicans because this is gerrymander. I litigated that case a couple years ago. We lost in state court. And they said, okay, so we're going to draw a new map. So the map on the left is the map that is in place today. And you can see it's not like it's on a river. Anytime a district's on a river, it's going to have a little bit weird shapes. And there's some weird things going on here too. But mostly that's like, they drew this district to satisfy the Voting Rights Act. But they also had some other like things that they want. Like legislators like things in their districts. They want like their homes. They want their churches. They want their mother-in-laws. They want things. So you get some weird districts. But the district is a district where blacks are a majority of the districts and they elect their candidate of choice. Nothing wrong with it. It's perfectly reasonable. The map on the right is the new map. And do you notice anything about it? Right, so you went from having this is only part of the state, but like this is a pretty compact part of the state, and they spread it out all the way up into Nashville, from Memphis to Nashville, hundreds of miles apart. But what is the effect of the map? It's not just that it's spread out that's the problem, it's what it does. Map on the left is the map that currently exists. And again, I don't know colors. Is it like blue and orange? I don't know what colors they do. I'm colorblind, so I just choose colors that contrast so that I can see them, but I can't tell you what they are. So the black voters are these dots, and the white voters are these dots, right? And you can see that they kind of like put the black voters all in one district and put the white voters on the outside. They didn't really have to do that. Like, it turns out that no matter how you draw District 9, the southwestern part of Tennessee, it doesn't matter how you do it, blacks always make a majority because Memphis is a majority black city. So it doesn't matter how you do it. But what you can't do is split it into 3 different districts. And what they did, they took District 9, majority black, put a third of them into District 8, a third of the blacks in District 5, and a third of the blacks in District 9. What happens? Blacks don't have a majority in any district, and they can't have any electoral influence. And I saw this happen, and I started writing something up. I was like, I got to write something up because, like, this doesn't happen naturally. You have to go out of your way to do this, which means it's intentional, which means it should be illegal. Right? Am I right? Like, you have to go out of your way to discriminate. Like, not everybody in Tennessee knows that Memphis is a black city. A lot of people outside of Memphis know this too. The legislators know it. They claim to not know it. Like if you listen to the dialogue of them passing this map, the Democratic representative says, "Are you aware, Mr. Speaker, that Memphis is a majority black?" He goes, "I'm not aware of that." She goes, "You went to law school in Memphis." But they didn't want to be on the record of saying they knew anything about race. They said it's all partisan gerrymandering. They said this in the court documents too. It's all partisan gerrymandering. All partisan gerrymandering. We didn't know Memphis was black. We didn't know any of this. You don't know this. How do you not know this? You knew this. By the way, there's actually a significant number of black voters in District 8 outside of Memphis. I didn't actually put that in my report, and I'm kind of pissed that I didn't now, because I think it's the best piece of evidence that they discriminate against black voters, is that they actually discriminate against the non-Memphis black voters even more than the Memphis black voters. But neither here nor there. I created this slide today at around 2 o'clock because I said, you know what? I ought to tell them about the evidence that I put in. This is my evidence from the court case. I said, I'm going to write something up. I'm so pissed about this. I grabbed some data that was existing already, 5,000 maps that somebody else had drawn that use traditional redistricting principles. They draw districts that are sort of compact and respect political subdivisions, the things the court used to say they cared about. 99.9% of those maps, so all but like 1 or 2, created a black district, a district where black voters had an opportunity to elect candidate of choice.
Wow.
99.9%. This is like smoking gun. You can't do this without discriminating on the basis of race. You cannot do it. It's impossible. 99.9%. Right? It's a complete outlier. Well, today at like 2:30, so I did this like 2 o'clock today, literally. At 2:30, like a half hour later, lawyer texts or messages me, emails me, court just ruled against us. The court said, nope, it's partisanship. It's just partisanship. You can't prove that it was race. When the two things are correlated, the Supreme Court told us we have to say it's partisanship. So I really don't have any words to say here other than like, this is where I had said for a long time, if there was any hope that we were going to protect black voters under the new doctrine, it'd be in Tennessee. Because it's a slam dunk case, 99.9%. You can't draw that district without like looking past race. You can't do it.
Is that a district court or?
This is district court. But it was a per curiam opinion, a 3-judge panel. I think, I'm not a lawyer, I think per curiam means that all 3 judges signed on it, and that includes the Obama nominee. Maybe we'll appeal to the US Supreme Court. We're going to lose, right? It's a foregone conclusion, I think. If you can't even get the Obama judge to sign on to it, I don't know what to do. They didn't even grapple with the 99% or anything. They just said the stated goal was partisanship, and under Rucho and under Callais, that's a legitimate goal. The other thing they said, I added this slide after I read the entire opinion today. They said, well, there's this thing called the Purcell Principle. And the Purcell Principle is that federal courts should not change election laws close to an election. But what they clarify here, and they're clarifying because the Supreme Court already clarified this, is that means courts shouldn't interfere with elections once they've started, but it says nothing about whether states can do it, right? So the argument of the plaintiffs, the side that I produced a report for, one of the arguments was they waited till the last minute to do this. Like, it's too late. The election's already started. They can't change it causes confusions to the voters, right? Candidates have already filed to run. They've already sent out ballots. And they did this in several different places. Alabama, they canceled the election. Louisiana, they canceled the election. They almost did it in South Carolina. They didn't do it. But the court said, actually, no. The U.S. Supreme Court has told us it's not about legislatures. They can do whatever they want. Courts just can't get involved. Here's my read on that. Legislature can change their map at any moment up to the election time, and courts cannot interfere with it. Which means you can basically discriminate against anybody and courts can never police against it. So let me see. What's left? We can go to state. We can go there. I think I had one more. I got so many more slides. Oh my God. No. Okay. So 3 weeks ago, I got a call from members of Congress. They asked me to come to DC to talk to a group called the Problem Solver Caucus, who has taken up partisan gerrymandering as their issue. They want to pass legislation under the elections clause to prevent partisan gerrymandering. They asked me to come talk to them. This is me talking to them. The person on the left is the person who drew the California map. The person in the middle is another political scientist from Stanford. At that meeting, Tom Suozzi, who is the co-chair of the committee, a Democrat from New York, asked questions about whether if we drew maps neutrally, would that lead to more competitive districts? And so, and I didn't know the answer to the question. We think yes, but we didn't know what the magnitude was. So I used the same data I had from Tennessee, but nationally. I took 5,000 maps from every single state. And I said, what happens if you draw all the maps neutrally, like without partisan advantage? Right? Do you draw more competitive districts? You do. You drew it's like goes from like 10% to like 15%. Still not a lot because we've segregated us politically, right? If you look at a map of West Virginia, you can see that Morgantown is blue and the rest of the state is red, right? So like some of it is innate, there's nothing to do about it, but like get rid of partisan gerrymandering, you will. But the other thing that I thought about in preparation of this talk was what about minority voters? Like how are they treated under neutral simulations? Well, my estimates are that in the Republican-controlled states, that there are currently 14 districts where blacks have an opportunity to elect candidates of their choice, currently, under the current VRA. So that's like before Louisiana gets rid of one of theirs, and before Alabama gets one of theirs, and before Tennessee gets rid of one of theirs. So before that, 14. Under neutral guidelines, it goes down to 5.3. It's actually not great, right? Like neutral principles don't get you there. That's why the VRA was so important, that we have to actually go out of our way to draw these districts, and that's an important thing. So neutral, now the one sort of asterisk here is this does not include Democratic states. You may actually increase the number, you actually do increase the number of minority districts in Democratic states under these simulations, and it basically is a wash. But of course, that's not really how things are going to work. And then the third kind of column here is what happens if all the states try to just eliminate the black districts, and you go from 14 to 2. Yeah, well, we're already down 3 of the 14, and you can still eliminate 1 in Alabama and 1 in Louisiana, and then South Carolina has 1 you can eliminate, Claiborne's district. There are still ones to go. The only state where you can't get rid of them, through partisan gerrymandering, is Georgia. And the only reason that's the case is because blacks constitute a large percentage of all voters in Georgia. And Georgia is basically a 50-50 state at this point. So it's like they won't get rid of those 2 districts no matter what, because it actually will hurt Republicans to do that. But everywhere else, you can see they're all zeros. They can get rid of all the rest of the black districts in the South. So that's our future. We get rid of all probably in 2030. Is they are not required to draw these districts, and now can just claim partisan advantage, and they can just get rid of them. If people want to know what the effect of the new maps are, what are the effects of the districts, the district lines on elections? So using the same election, the 2024 election, and just putting those results into each of the different maps, the map that was used in 2022, the map that is in current use in 2024, and the map that will be used in 2026. The effect is to eliminate 7 districts where Kamala Harris won, and to add 7 districts for Trump. So that's the effect. That's the bottom line conclusion. My other slides kind of did the same thing with lots of other data. This is sort of the more simple way to do it. Right? The lines matter. The voters have not changed to these maps. The voters are having the same preferences, right? And it's gonna be even worse for Democrats than that once Republicans are able to undo the rest of these Hispanic and black districts. All right. Oh, and the last slide. One last slide. So this is the last 2032, right? So after the next decade, we're going to have a new apportionment, abortions in the Constitution. And just based on population changes, this is my estimate, right, that Pennsylvania is going to lose 1 district. New York is going to lose 1 district. Rhode Island will lose 1 district. Wisconsin, Minnesota, Oregon will lose 1 district. And and California is going to lose 3 districts. And Idaho, Utah, Arizona, Georgia, all going to gain 1. Florida going to gain 3. Texas is going to gain 4. Oh, and Illinois is going to lose 2. So by my count, that is 9 Harris districts that are going to be moved to Republican states. Means the control of who draws those districts flips. So this is I'm sorry to have now taken up an extra 10 minutes. Alex is going to be really mad at me. I'm sorry to have gone on for a long time. I think it's really important, right? We can go out and have elections and do all these things, but they're sort of doesn't matter if they can just redraw the lines and cancel people's votes, right? So this is really important. We need to have reform. This is the area in which we do it. There's a reason why the Republicans spent so much money on not really that much, but money on state legislative elections in 2010. They knew that getting that advantage would mean not having to run congressional races. They could just win those districts without having to run good candidates or spend money, right? They don't have to do the hard work. This is the easy work, right? And the Supreme Court doctrine was already convoluted, right? You've seen how convoluted it has been. It's even worse now. It is not protecting minority voters. It's downright hostile towards Democrats, right? The only satisfying thing was they let California go ahead with their map. But that's not even satisfying to me, because the effect was to discriminate against Republican voters in California. And that's not what I want in a democracy, right? We want all voters to have an equal say in their elections. So anyways, I have nothing else. I do have one other thing. This is just kind of a funny thing. You'll laugh. The thing I've been working on over this summer is developing a game, an app, where you have to guess the district. It's called Daily District. It's not released yet. If you want to, I created a special link, dailydistrict.com/Micah, and you can play. But that's all I have. And I can take questions and do that.
I've been thinking, as you're talking, that the only solution is to win this election and increase the number of Supreme Court justices.
Well, I hope not. I mean, so like packing the courts is certainly something that people say can do. I mean, I hope that's not the case. I don't know that we have to pack the courts.
Give me another alternative.
Well, I'll give you my alternative, right? So when I've had reporters ask me this question, and I say, well, yeah, certainly it is a tactic, right? If the problem is that the court doctrine is messed up and it's the justices of the court that determine the doctrine, you got to change the court. So one way to do that is to increase the number of justices, and we can do that. We can also do other things. We can strip the court of jurisdiction. So if there's any lawyers in the crowd, like they know more about this than I do, but you can say the court doesn't have control over the Voting Rights Act. They're not allowed to judge that anymore. We can do that. Congress can do that under the Constitution. The other thing, and this is my preferred solution, is for people to go and to vote, and for it to be so overwhelming that it can't be silenced to the justices, that they recognize that voters are unhappy with these decisions and that they overturn their own presidents. And that itself is not unprecedented, right? So FDR threatened to pack the courts because the court kept blocking the New Deal. They understood that the voters who were electing Roosevelt and Democrats in overwhelming numbers, they recognized that they had to change. And so if you've ever heard the sort of quote, like a switch in time saved 9, right? It's because like the justices recognized that their decisions were unpopular. They switched, and it meant that they didn't have to pack the court. So that's my preferred solution. I don't want to pack the court, because that is not going to end well, right? It's going to be Democrats pack the court this time, then Republicans pack the court next time, or they go down, and they go up, and they go down, and it's instability, and we're just lawless. So the better one is just for the court to recognize that this is what they've done is an error, right? Rucho versus Common Cause is the sort of the main problem, because we wouldn't even be in this situation. So Tennessee can undo their black district because they can claim it's partisanship. But if you can't make that claim, they can't do it. It's only because they allowed them to make that claim that partisanship is the goal, right? So we just need the court. You're probably right that we probably have to pack the courts, right? Because they're probably not going to. I don't see Sam Alito changing his opinion. But the other thing, like, this is not like a hopeful thing in a sense. Like, people die, right? And like the justices in the court are going to die, right? Like, and especially some of the conservatives are older. Like Thomas has been on the court since I was a kid. Was it 88 when he went on the court? 91. Was it 91? 91. Right. And Alito has been on the court since the early 2000s, and they're both in their like late 70s.
That's not old enough.
Yeah, but if they die now, who's going to appoint the new ones? You don't want them to die.
You're not wrong, but they're different people who see the world in different ways. So even if they're conservative, it doesn't mean that they'll agree with everything that these justices say. And also, like Democrats could win elections, win the presidency, win the Senate, and just nominate better candidates or better justices to replace them when they do die. I mean, Ketanji Brown Jackson has been wonderful on the court in dissent, right? If you read her dissenting opinions, she's very, very. She understands history, so. It's really ironic that a lot of justices will say that they're originalist and then they ignore the originalism of the 14th Amendment. But she'll tell you what it is, right?
Yeah, but it's still a dissent.
There's still dissent. But dissents sometimes come back as majority opinions later. I'm just trying to be a little bit hopeful. You're probably right. We probably got to get packed the court, or otherwise it's a 20-year project. But a lot of these projects are long-term. Democracy is a long-term project, after all. Right? I mean, people want it to happen today. I want it to happen today. But it's just not the reality we live in, unfortunately.
I sort of wonder if the reason they left one black district in Louisiana is that even in a racist white majority state like that, that would, if you can still point and say, hey, look, we're not completely racist, we got one token black. Take that away, there might be a map, there might be a whiplash effect on some of the white voters that may say, that was too far for me.
Well, they didn't think that way in Tennessee. So I'm not saying you're wrong. I think you might be right. I have other theories too. So in South Carolina, they could have taken Jim Claiborne out, and they didn't. The legislature chose not to do it. Why? Well, my theory is Claiborne is a powerful representative. He's a leader in the Democratic Party, and he brings back the bacon. Or whatever whatever they call it, right? Like he brings back money to the state, and so like they might not want to lose that. They also have relationships with these people, so like they may have said, well, these are our friends, even if like you disagree with them politically, they're our friends. There's also one other, maybe cynical or maybe less cynical reason. I'm not sure which one it is. You can decide. If the Democrats take control of the House of Representatives and or the Senate and or the presidency. If you're a state that has no representation for the majority party, you might be in a lot of trouble when it comes to like getting money. Like Trump has been particularly vengeful as a president compared to anybody else in terms, like you can see like federal funds has diminished in blue states. Like he targets the blue states. And so we're recording. Let me just say that like I think it's probably a good thing in Pennsylvania for people in Pennsylvania that we have some Republican senators, a senator that is Republican. I think it has probably saved us in terms of some federal funds. I won't say anything beyond that. I have a strong inclination that it's been beneficial for us to have some Republican representation. And so I think that might be another reason. Like they recognize that Democrats are very likely to take control of the House of Representatives in 2026. You want to have somebody in the majority party in your state. Tennessee didn't care. There's also one other reason I think that maybe they didn't do it is because they might have thought it was illegal. Right? They might have thought that it's actually illegal to disintegrate black majority districts on purpose because that's logical. Right? We thought that was the doctrine. Today, I'm not sure. After the court today, I'm not sure. They think they were maybe running a little bit scared that they would have their maps struck down if they got rid of all of them. Right? It's hard to reconcile how you can know that a district is black majority and just dismantle it. Right? And so again, not that like my brain has a lot of things in it, but like Alabama and Louisiana particularly, like they moved back to maps that were before the court ordered them to draw more maps. Right? If they would have eliminated the black district in New Orleans or the black district in Birmingham, you'd be eliminating districts that were not required by the court. So I think they were actually scared that they were going to get those maps struck down. But I don't think they're scared anymore, not after today. Well, let's see what the Supreme Court says. Maybe they'll overturn this district court. My inclination is that because the Obama judge signed on to this opinion, I think that pretty much guarantees the outcome. There's no dissent, right? There's no dissenting opinion, right? Dissents can matter, right? Especially when it comes to district court. In Texas, the district court ruled that the maps were a racial gerrymander. The Supreme Court cited the dissent in overturning it. Crazy, crazy opinion. If you want to have a trip, go read that one tonight. The guy was really mad. The dissenting judge in the Texas case was really mad at the other judge, the other Trump appointee, and he unleashed on him in a court opinion. It's wild.
Any more questions? Cynthia?
Yeah, I've got a question a little bit different. Have you been following what's going on with the planning for the 2030 census?
Yeah.
The pre-planning thing, how they're screwing with everything. Normally they have, where they do that, the sampling thing, and they to create a kind of a model for what would happen in terms of allocation of funds and staffing and stuff, where they're going to have postal workers doing it instead of trained people. For the pre-planning one, they're reducing it from 6 to only 2, so it's not going to be really representative. And
well, the census is not representative anyways.
well, I mean, but they say that as a result of these changes, it's likely to even more egregiously undercount minorities. You know, tribal lands, all different types of, different aspects of minorities. And I'm sure you've got some thoughts on.
Yeah, I mean, I haven't followed it really closely, but I mean, I've certainly seen, I get like emails about these things, and I've seen that they've cut the test sites, they've moved them to different locations. It's all like problematic in lots of ways, but it might be overstated in some ways too. There's always undercounts in the census. So that's always a problem. We don't want it to get worse, certainly. It's not clear if this will make it worse or better. Like the one sort of like thing that give me a little bit of caution to say too much about it is we don't know who's going to run the census, right? The president who's elected in 2030 is going to be the president, or 2028 will be president in 2030 when the census happens, right? So like that's not Donald Trump, although he said today he's going to run again. But it's likely not Donald Trump, right? Or the Trump administration. And so like they'll have some time to recover. The census is robust. The people there they're career politicians or career civil servants, not politicians, and they are statisticians and they do a good job and they try their hardest to get it right. They do get interfered with by politicians. Donald Trump was president in 2020 during that census, and it was relatively worked out okay. That was during COVID too, when things were really like not good. And the counts were bad. But they weren't like historically bad. They were bad in a similar way that they were bad in every year. It's because it's hard to count everybody. So it is bad, like it is, there are worse things that are looming. So the map I showed you of apportionment is apportionment just based on population changes. What if we change the way we count people and we only count people who are citizens, which is what the Trump administration has been trying to do for 10 years, right? They've been wanting to only count citizen populations. I have a map of that. I don't have it on my slides. It changes the numbers quite drastically. Especially if they can use that data for redistricting purposes, because it will shift districts from urban areas to rural areas. So those are, to me, at least they're the problems I think about more. Most people answer the census by internet nowadays. That's why the 2020 census was pretty robust. It was all internet based. People didn't have to go and knock on doors.
Ron, you have one last quick question.
I don't think it's going to be quick.
Let's go get a drink.
So, thinking about the Supreme Court, the question about the Supreme Court, term limits, is that something that, well, surely it's something that could be done. Term limits, that's one. Also, too, that instead of making that court political, which it is because justices are picked by partisan situations. Okay, we've seen that here in recent history. What would happen if we picked justices from lower courts to sit on the bench for a limited period of time, and that they're selected through lottery? So there's a decreased risk of political influence.
So term limits unconstitutional for members of Congress. Court ruled that in 1992, I think. So not for members of Congress. For members of the court, probably, right? Because Congress determines the composition of the court. Right? That's why you can pack the court.
The Supreme Court, the Constitution says justices serve until, while they're, whatever it is, for life under good behavior.
Yeah, it doesn't really say it's true, but you could still strip jurisdiction from them. So you could say they're still Supreme Court justices, but they don't hear cases. The Supreme Court isn't determined to be a 9-person Supreme Court the way it is. That was done through statute. So it can be changed, right? I don't know, I'm not a constitutional scholar. I don't know whether it would be constitutional or not to have term limits. It's certainly been, people have said we should have 18-year terms that are staggered so that we can have them regularly and then they fall off the court. But they could still be judges, right, that just they don't sit on the bench and get the rule in the same way, I would think, right? They can strip them of the jurisdiction, right? They can still be judges with they just have to go sit circuit. justices used to sit circuit anyways. Like back in the 1800s, a Supreme Court justice had to go, and they called it riding the circuit. And they had to go and hear lower court cases, the Supreme Court justices. They can make them do that again. They won't want to do that, right? That'll make them quit, right? But why not do that, right? Like so there might be ways, right, to do it. And what's the second part of the question?
That's good.
Hey, let's thank Jonathan.
You can ask me again later.
Thank you all for attending.